It's just preparing to stream it.
All right, let me know when I can begin.
Right, you can proceed now.
All right. Thank you, Justice Torres. The Supreme Court of Guam is now in session. Will the clerk please call the case?
This is Supreme Court case number CRA19-013, in re People of Guam, Plaintiff Appellant versus Gerald Wayne Cruz II, aka Gerard Wayne Cruz II, Defendant Appellee. Appearing for the Plaintiff Appellant is Attorney Stephanie Mendiola. Appearing for the Defendant Appellee is Attorney William Bischoff. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Mendiola reserves 10 minutes.
Thank you. Hafaday, Attorney Mendiola, Attorney Bischoff, and the students, teachers, and professors from John F. Kennedy High School, University of Guam, and any other schools who may be joining us today. I also greet the members of the general public and the media who may be viewing this hearing on the court's YouTube channel. I am Chief Justice F. Philip Carbolito, and along with my colleagues, Justice Robert J. Torres and Justice Catherine A. Merriman, I wish to welcome you to the virtual courtroom of the Supreme Court of Guam. Every year, the Supreme Court partners with one of the island's high schools or colleges to hold an outreach appellate argument, usually held during our Law Week festivities in May. The court hears live arguments in a real pending case in front of hundreds of students. This event provides students with the unique opportunity to witness firsthand the appellate process in action and to participate in a question and answer session with the justices and attorneys in the case. Under normal circumstances, an outreach argument entails bringing the courtroom to your campus with the justices, attorneys, court marshals, and courtroom recording equipment in tow. But just as your way of attending classes has changed, so has the way of our court hearings. Since the start of the public health emergency, the Supreme Court of Guam has become a virtual court, hearing all our cases over Zoom with a live stream on YouTube. Although a virtual courtroom has its share of challenges, it has also certain advantages, such as an event like today, where we can provide access to a Supreme Court hearing without the limitations of space in a physical courtroom or even the constraints of the public's time, since a recording of our virtual hearing can be viewed on your YouTube channel any time of the day from any part of the world. Before we start today's hearing, I just want to give you a brief overview of the function of our court. I am sure when students and adults think of a court hearing, they imagine the trials they see on shows like Law and Order, where witnesses take the stand and jurors decide the fate of someone charged with a crime. I just want to warn you, this is not what you will be seeing today. Trials are heard in the Superior Court. When a decision is rendered in the Superior Court, which is our trial court, the parties have a right to appeal the decision to us, the Supreme Court. An appellate hearing does not involve taking evidence from witnesses or viewing exhibits, and there are no jurors involved. Instead, the issues are argued by the attorneys representing both sides, while the justices ask the attorneys questions about the law and the record pertaining to those issues. Definitely not as exciting as Law and Order episode and a Law and Order episode, but to the parties who come before us, we represent, for the most part, their last resort at winning their case. I'd like to thank the counsel for today's case, Attorney Stephanie Mendiola of the Attorney General's Office representing the people of Guam, and Attorney William Bischoff of the Public Defender Service Corporation representing Mr. Cruz, for graciously agreeing to not only argue in front of a much bigger audience than they're probably used to when arguing before the Supreme Court, but also to answer some of your questions after the hearing. Now, Justice Torres will briefly share some housekeeping rules, and then we will get started with today's hearing. Justice Torres?
I have to unmute, which is, I guess, the most famous term in 2020. Thank you, Chief Justice Hoffaday, and good morning, students. I'd like to go over some brief housekeeping and logistical rules for those of the students who are joining us today in the virtual courtroom gallery. All the students are currently non-video participants and are muted. You will only be able to hear the justices, the attorneys, and the courtroom clerk. Questions from students will be fielded through the Zoom question and answer box. We encourage you to submit questions throughout the court proceeding. After the appellate arguments are completed, the justices and attorneys will respond to your questions and comments. If you would like to join us in the virtual courtroom to ask your question as a video participant, please indicate by putting the word invite at the end of your question. If you do not write invite after your question, although your question will be asked, you will not be invited into the virtual courtroom. Please be advised also that the justices are constrained by the Code of Judicial Conduct from commenting on pending cases. Therefore, they will refrain from answering any questions concerning any pending cases before the Supreme Court, including the case that is being argued today. The justices may address questions about the appellate process, about their preparation for oral arguments, about the impact of the pandemic on the courts, or other general questions about the administration of justice or the law. The attorneys are not subject to the same ethical constraints as justices. And so the students are free to ask them questions about the merits of their case or any other matter that may not be confidential or privileged. Thank you for your participation today. And on behalf of the Supreme Court, we hope you enjoy the arguments.
Thank you, Justice Torres. And also, I'd just like to acknowledge the third member of our panel, Justice Catherine Merriman, which you see on your screen. And so at this time, counsel, Attorney Stephanie Mendiola, representing the people from the Attorney General's office, you are recognized.
Caesar's Mossy. Manana Caesar's, Mr. Chief Justice, may it please the court. In May 2018, when Gerald Cruz went to his neighbor's house, shot his neighbor's cat, and threw it in the back of his Tacoma, he caused serious physical injury to the cat. 4 months later, when he went to his other neighbor's house and shot 2-year-old Pugwa, a part Jack Russell, part Booney mix, he caused serious physical injury to Pugwa. The bullet of Mr. Cruz's .22 caliber rifle pierced through Pugwa's chest and shoulder, sending shock waves through the tissue of Pugwa's body. He suffered excruciating pain and immediate lameness, leaving him unable to walk. He eventually bled to death. This case is about who gets to decide crime and punishment. What is the crime of animal abuse, and how do we punish animal abusers? In our system of government, it is the legislature and not the court. The legislative branch creates the laws, and the judicial branch, of course, interprets the laws, but in line with the intent of the legislature.
Attorney,
An issue in this case.
I apologize for interrupting just for a second, but we've lost Justice Torres, and I'm just going to ask his chamber administrator, Ms. Jackson. Jessica, if you could just try and reach Justice Torres and and just find out what if he's going to participate by calling in or trying to log on again. Although we have the benefits of our virtual courtroom technology and making it convenient for everyone to argue from their place of employment or residence, we also have our challenges when the internet goes out. And so, so if you just, and you can stop the clock there, whoever is handling the clock.
So
Okay. I'm
I
starting.
am back in by video now.
Okay.
So I am back in. Excuse me. I don't know at what point we had the problem in terms of.
From the time that you dropped off, I probably had Stephanie continue for about a minute only. I just wanted to see if you were just going to come on momentarily. When you didn't, I asked her to stop, and so we're going to go ahead and resume. And from where you left off, Stephanie. So I apologize, but please go ahead and continue. You are recognized.
No problem, Your Honors. Justice Torres, I know it was just the opening so strong enough, you already made up your mind. But in all seriousness, where I left off was addressing what is the crux of this case. And this case is about who gets to decide crime and punishment. What is the crime of animal abuse? How do we punish animal abusers? And in our system of government, it's the legislature who gets to decide and the court who interprets the laws in accordance with the legislature's intent. So at issue in this case is the interpretation of the law that created the felony crime of animal abuse and the corresponding punishments. And the law is clear and unambiguous. It is a felony crime to cause serious physical injury to an animal, and it remains a crime regardless of whether that animal lives or dies. As Justice Merriman and Justice Carbolito were explaining to the students the procedural posture of this case, the people charged defendant Cruz with causing serious physical injury to these animals. But the trial court erroneously dismissed these charges based on its own interpretation that the law required the animals to survive in order for the crime to be committed. But that is not what the law requires, and that is not what the legislature intended. So we ask this court to correct this error, reverse the dismissal, and reinstate the indictment to allow the people to proceed on these charges. And this court should do so for 3 reasons. First, the plain language of the animal abuse law is unambiguous on its face. Second, the plain language is supported by the legislative intent here. And third, even if the law created an absurdity, as the defense argues, it is not of the type that the court is allowed to correct.
Let me ask you, Mr. Mendiola, can I ask a question here? The trial court in dismissing the indictment held, as you pointed out, that the felony animal abuse would only be applicable in cases where the animal survives its injuries. And they said that the absurd result of the felony animal abuse statute would apply in all cases where the animal is killed. In this case, are you suggesting that the Attorney General can determine whether to charge someone as a felony or as a misdemeanor in a particular case, depending on the prosecution's whim?
Yes, we are. That is entirely within the discretion of the prosecution.
And can you, just one follow-up, Chief Justice, so are you also able to charge the person with both the felony and the misdemeanor? The felony under 70.10.1 first degree, and then also under the misdemeanor statute for under killing under 70.10?
Yes, we are. The law allows the government to charge a defendant for multiple crimes if the facts of the case support that even in a single action, the defendant committed multiple crimes, the government's allowed to charge one, some, or all of those crimes. Of course, the issue becomes whether the defendant can be convicted of all of those crimes, which he or she cannot, and the defendant cannot be punished, therefore cannot be punished for all of those crimes. But whether the government can charge those crimes, the answer is yes.
Well, that's a little troubling to me, and I just rewind this tape just for a short while. And if you listen closely to Justice Torres's question, he says, can the government charge at its whim in terms of deciding under which statutory section to charge? And that's troubling to me if you agree that the government can, at its whim, decide what code violation to charge. And that's a little different from saying that the government can charge multiple offenses arising from a single conduct. And so to me, if, for example, in this particular case where the defendant comes, shoots a dog, and then from that factual pattern is charged with the felony animal abuse statute, and if the neighbor on the following day shoots a different dog, and then the AG decides to charge under the misdemeanor section of the statute. So it's just totally at the whim of the AG's office, so it picks and chooses. It may not like the caliber of weapon that one neighbor used as opposed to the other, and so that you're saying that under the current statutory scheme, the Attorney General can conduct itself in this manner?
I suppose since the issue here is one of statutory construction, we go back to the point that words certainly matter. So if the issue is whether or not the government can charge at its whim, I might step back from that to say that it's not that the government can't charge at its whim, but not too far back, because it's really the government's authority and ability in deciding how to charge the case. It isn't one of whim. It's one of prosecutorial discretion. So the government is going to look at the facts that it has before it to determine what charge to bring. So in both those cases of your hypothetical, if one person shoots their neighbor's pet and then a different person shoots another neighbor's pet, will those cases be handled differently and will those cases be charged differently? Maybe yes and maybe not. And is that a decision that the prosecution is going to make? Yes. At its whim, maybe not.
Well, what are some examples of how the Attorney General can exercise its discretion in a non-discriminatory way? And if under the hypothetical, we had two neighbors shooting an animal, and which resulted in death, and one is charged with a felony and the other is a misdemeanor, what may be some of the factors that influence a prosecutor to charge one with a felony and the second person a misdemeanor under same factual circumstances?
Well, the other factual circumstances would have to be different. So if two people if one neighbor is shooting a pet and the other neighbor is shooting a pet in these unfortunate circumstances, the facts would depend. And you bring up one factor that could potentially be relevant is the caliber of the weapon, the type of the bullet, the purpose for the shooting. There are humane ways to kill animals, and the type of weapon and the type of bullet actually come into play in those determinations. Where is the neighbor's animal? Is the neighbor's animal at its own house or at a house it rightfully could have been in, as in this case when Gerald Cruz went to his neighbor's house to kill the animal? Or is the animal the neighbor's animal, but it's at the defendant's house and it is destroying property, it's um, potentially carrying disease, which in some cases animals do. All of these different circumstances are what will guide the prosecution's discretion in what to charge. But at issue in this case is not so much the prosecutorial discretion to do so, although that is what is being seriously impeded here, but that's rooted in what the law is here that the legislature created. It's within the legislature's prerogative to decide that sometimes the killing of an animal can be a misdemeanor, a less severe crime, and sometimes the killing of an animal can be a more severe crime. But in all of those cases of a killing, there is serious bodily injury to the animal, and that's the case here. And the indictment in question is based on a charge of causing serious physical injury. So
So under that interpretation, and under that interpretation, which of course the trial court vigorously disagreed with, then as the trial court announced in its decision and order, then the misdemeanor statutory section of 70.10 point, I think, A3 becomes superfluous, and that in all instances where there is the shooting of an animal that ends in the animal dying, the prosecution's contention is you always have serious bodily injury, and that therefore there is not a need or for the misdemeanor violation, because it always constitutes a felony, and as in this case, the Attorney General's office chose only to charge the felony, and earlier you contended, well, we can do both. We can charge both the felony and the misdemeanor under other Supreme Court case law. But in this particular case, the example kind of supports the trial court's view that the misdemeanor statutory section becomes superfluous. Is that the case?
It's not, Your Honor, and it's not superfluous for multiple reasons. It is true that in the case of every killing, there is serious physical injury to an animal, and by that logic, there is physical injury to the animal. But that's not only based on physiologically speaking, because of what the animal physically goes through and suffers on its way to death, but also legally, because the way that this statute is constructed, physical injury and serious physical injury were both separately defined and then intertwined in their definitions. It's also not superfluous because the misdemeanor killing of the animal is accompanied by additional elements, for example, ownership. So in a misdemeanor killing of an animal, the element would have to be established that the person committing the killing is not the same person who owns the animal. So it's not superfluous, and it is in line with the legislature's intent to create these two different statutory frameworks, if you will, which is what the defense and the trial court argue. There are two frameworks, so they're correct about that. But what they're wrong about is what those two frameworks are. The two frameworks are not dependent on survival. The two frameworks they could be dependent on, well, the two frameworks are animal abuse in the first degree and the second degree, clearly tied to severity, one more severe than the other. But for whatever the legislature's intent was, they could have been, as Justice Carpelito, you mentioned, tied to different factors of different cases that the government should consider in bringing a charge.
Ms. Fandiola, looking at the definition of serious physical injury in subsection H, doesn't that language indicate that there wouldn't be death? Because it says creates a substantial risk of death and so forth.
Would the definition mean that there wouldn't be death because it creates a substantial risk of death? No, I think, not what I think, but not only what I think, it happens to be hopefully what you believe is right here. The court, this very panel, I believe, found in Nathan that it's the highest risk of substantial risk of death is death itself, right? And it looked at the comparison between aggravated assault and murder and homicide cases, homicide crimes in that case. So the fact that serious physical injury is defined as physical injury creating a substantial risk of death, that's the most substantial of risks is death itself. Additionally, that definition includes other elements that are present in this case for present in Fuqua's case, which is impairment of health or impairment to the function of a limb or a bodily organ. And what I was mentioning earlier, when you trace back, serious physical injury starts with the definition of physical injury, which is another term that the legislature defined here. Which is another term the legislature defined here. So while it's not entirely impossible that the interpretation of the defense in the trial court is one interpretation of the law, it just goes too far. The plain language of the law is supported by the legislature's intent to have strengthened the punishments against animal abusers at the time. The law in question, section 70.01, 7010, and 7010.1 were enacted through Public Law 31-5 through the 31st Guam legislature. It originated in the legislature as Bill 9, and in the public hearing for that bill, there was a strong showing of support for the legislation, and it was the legislature's finding that the laws at the time were antiquated, and quite frankly, they weren't strong enough. They weren't strong enough to serve as a deterrent to animal abusers. There was an outcry in the community for strengthening animal abuse laws, and in doing so in a way that allowed the government to actually charge these cases. At the time, animal abuse was a petty misdemeanor, the lowest level crime.
Let me ask this question, Ms. Mendiola. The government, the people originally indicted this case in the superseding indictment for cruelly causing the death of the animals. And the trial court found that the indictment offered no facts that the cat or dog suffered before dying, or that Cruz intended that they suffer. And while cruelty or cruel is not defined in the statutory scheme, the judge relied on Black's Law definition of cruelty. And then the people obviously changed their direction and did not include cruelty in the second superseding indictment. Why couldn't the people have indicted on the cruelty killing of an animal and gone forward with asserting facts on that basis? Were they trying to avoid?
So Justice Torres froze, and did you get the gist of his question?
Yes, I did, Your Honor. Should we give him another minute to try to get back in before I answer?
Okay, just give him a few seconds, and then we'll why don't you go ahead and take a stab in reference to well, he's coming back in. You are muted, Justice Torres. Yeah.
Yes.
Yeah, you can go ahead and finish the question she was about to answer. I think you got the gist, but just answer the finish.
Okay, yeah, the question was, why couldn't the people have indicted on cruelly killing as opposed to proceeding in the manner in which they did?
The people actually could have indicted on cruelly killing, and the people did indict on cruelly killing in the second version of the indictment. And again, the trial court, reading in its own interpretation, dismissed that indictment on motion by the defense. the gist of the argument at that stage in the proceedings is that killing an animal by gunshot could never be cruel. That's entirely unfounded. While there are uncruel ways to kill an animal with a gun, namely humane ways, which are guided by practices and principles for doing so, it is entirely true that you can cruelly kill an animal with a gun and through shooting.
Well, I think the trial court determined that you didn't offer any facts to support the conclusion that that there was a cruel killing. And so if the people had gone forward, I mean, there appears to have been testimony from the territorial veterinarian and the manner in which one of the animals passed away. And it seems that the people could have proceeded, but instead in the second superseding indictment that and didn't proceed in that manner, and didn't proceed on the definition of cruelly killing.
The people did not, Your Honor. First, to the point of whether facts regarding cruelty were alleged. Again, we're at the indictment stage, and the language required for sufficient indictment is a very low threshold. The fact that the grand jury supported what the government presented was enough to bring the charge forward from the perspective of the procedural requirements that the government needed to have met. In that indictment, it was alleged that Cruz shot the animals. Cruelty is a fact-specific determination, and those facts are entirely the goal of going through the trial process and are facts to be presented before the jury. At the indictment stage, there are different goals, all of which were met in this case. And yes, the people did not proceed on appealing the judge's wrongful decision at that stage, but that's not what's controlling here. For whatever reason, the people didn't decide. What controls here is that this indictment is properly before the court. This indictment is also sufficient, and the law does not require the element of survival, which is the single factor for which the trial court dismissed this indictment. And I see that my time is up, so I will reserve the rest of my time for rebuttal.
All right. Thank you, counsel. Mr. Bishop, you are recognized.
Thank you, Mr. Chief Justice Carbolito, and may it please the court. All that we are saying, all that we have been saying all throughout this case is that it should be it's a misdemeanor, not a felony. That the facts alleged would support a conviction. The facts alleged, if proven, would support a conviction of a misdemeanor charge of killing the animal of another, but not the felony of cruelly killing or torturing or causing serious physical injury. Causing serious physical injury is a term of art. It's defined in the statute. It's defined as causing a substantial risk of death. And in this case, the obvious result was death, not a substantial risk of death. It was death.
Yeah, but Mr.
Yes.
Bishop, just in reference to the definition, it also doesn't read that does not result in death. The argument is that of the government, it's, as you've heard Ms. Indiola state, it's a very simple, straightforward case of statutory interpretation. And in reference to the section 70.10.1A3, the felony, third-degree felony violation, the argument is that the shooting of the animal constitutes resulted in a serious bodily injury. And under the statute, when, as you point out, you define serious bodily injury, it doesn't necessarily say that does not result in death. And in this particular case, the argument of the government and the trial court actually the government, is that it can constitute a violation of both the misdemeanor and the felony statutory provision. And so why is that not the case?
Well, first of all, as Your Honor pointed out, with the interpretation given to the statute by the Attorney General's office, that would render the misdemeanor charge completely superfluous, surplusage. It would be.
But she also argued not necessarily, because they could have charged both. They could have charged both statutory violation in terms of two offenses arising from the same conduct in terms of prosecuting for two offenses arising from the same conduct. And as she pointed out, not necessarily convicting for both offenses. And under our prior case law, that is permissible.
I agree that they could have and that they should have, but they refused to charge this as a misdemeanor. This is the paradigmatic example of killing an animal of another. Someone shoots the animal, directly causes its death, whether immediate or within a few seconds or a minute. The shooting directly results in the death of another person's animal, and that's what the misdemeanor charge covers. The felony charge covers torture, cruelly causing the death, which the trial court already dismissed the indictment when they charged cruelly causing the death. So now they've fallen back, trying to hang their hat on that it causes substantial risk of death. Serious physical injury, which is defined as causing a substantial risk of death, protracted disfigurement, impairment of health, or impairment of a limb or bodily organ. You have to read those terms they're associated terms, is the Latin phrase, nocitur associis. Associated words draw their meaning from each other. The definition here for serious physical injury, what you envision when you read these words associated together, these phrases, is a lasting injury, which when it comes to animals, the text of the law is pretty clear that killing an animal instantly or as quickly as possible is actually the preferred happening. It's better than injuring an animal and having it suffer prolonged impairment of bodily organs, protracted disfigurement. You have to read those words associated.
Well, that can be in terms of a person intending to euthanize an animal so that the animal no longer suffers. That doesn't apply in all cases when someone shoots an animal and the animal ends up dying. I mean, in this particular case, you had the veterinarian testify that the projectile caused a lot of pain and suffering probably to the animal before it died. That was his or her opinion. And so it's not necessarily that every time you kill an animal by a gunshot, that is the least painful way for an animal to die. There can be instances where that's the case, when an animal is already suffering and the intent is to euthanize the animal. But I don't necessarily see that the facts of this case suggest that that was the circumstance in this manner.
Well, this case, it was a kill shot. It was to the chest. It went through the primary organs. The dog died within a matter of seconds or a minute. The shooter obviously intended to kill. And one question now that has risen as well, did the dog move? Was he slightly errant in his shot? And with the result that the dog survived for a few seconds or a minute. That happenstance. He used a gun, which is the most deadly of weapons. Obviously, you're intending to kill when you use a gun, and in this case, that is the result. The dog died directly from the gunshot within a minute or so.
So you're suggesting that it's
so
under that
are you
circumstance, there's no serious bodily injury to the dog? I'm sorry,
Yes, yes, because of the statutory definition of serious bodily injury, which is a substantial risk of death. This wasn't even a substantial risk of death. This was a practical certainty of death, which is the terminology of a knowing crime. In fact,
what about the impairment of the organ, as Ms. Mendiola pointed out? I mean, even if you look at the additional definition, you just indicated that the gunshot penetrated the organs. So why isn't that an impairment of the organ warranting a charge under this definition of serious physical injury?
because that would render the misdemeanor charge completely never applicable. The legislature obviously had something in mind. The legislators had something in mind when they passed the misdemeanor statute, which says it's a misdemeanor to kill the animal of another. In this case, that's obviously what happened. The animal was shot and directly died. This is the paradigmatic example of the misdemeanor, and the prosecution is trying to get around that and charge it as a felony with instead of a 0 to 1 sentence, 5 to 28.
But why isn't it important for the government to be able to have discretion considering the factors of what went into the killing in deciding whether to prosecute it as a misdemeanor or as a felony? I mean, you know, whether it reflects a propensity to commit acts of violence, what's best to deter the future conduct, etc. I mean, why is, yeah.
Yeah, I was going to say, I'm sorry, that's a legislative choice, not a prosecutorial choice.
But they didn't limit, as Justice Carbolito pointed out, they didn't have limiting language in 70.10.1 that says that when death results from serious physical injury, that means you can't prosecute under that provision. And as a follow-up to that, you seem to suggest that anytime there's a killing of an animal, within a minute or so, he dies after infliction of the injury, that can never warrant a felony charge. So you're suggesting that killing an animal, as the judge found here, by shooting can never be cruel under any circumstances?
No, if there were facts to indicate that the shooter intended the dog to suffer for a minute before it died, that might be different. But here, where there's no facts to indicate that the shooter intended the dog to suffer for any indeterminable amount of time before it died, when you use a gun, I mean, the presumption is that's the quintessential killing instrument. It's not like you hit it with a rock or a stick or a machete.
So under your interpretation, if the shooter starts by shooting the toes, shooting the leg, shooting
that's torture. That's torture.
That and then would be the scenario where the felony charge would kick in, and that's the serious bodily charge and intended to act in a cruel manner, and that would be the circumstance that the legislature only intended when it can constitute a felony charge.
Under that scenario, you have torture and cruelly killing. I'm not sure that scenario would encompass the serious bodily injury. I think serious bodily injury, as defined in the statute, what it conjures up is a lasting injury. We talk about protracted disfigurement, impairment of a limb, or impairment of a bodily organ. Those words are all in the same section of the statute. They must have a related meaning.
So the only
what about it?
I just want to follow up then. So I'm just trying to get the different scenarios in reference to Mr. Cruz's interpretation. So if the perpetrator was to beat the dog using a club and cause some other type of injury, and that in your mind would be what serious bodily injury, and that would then be permissible to charge the felony, as opposed to when the perpetrator shoots the dog and kills the dog, and that would not be a serious bodily injury. Is that the
No, no.
argument?
What your honor is describing is torture or cruelly killing. If the dog, if you shot the dog, say only in the leg or the paw, and intended it to suffer an impairment of a limb for an extended period of time, which would be obviously the obvious intent of the shooter, to not make a kill shot, to purposely, to intention, or even recklessly, to shoot it in a paw, as opposed to a headshot or a heart shot, which is, obviously what the legislature is the preferred outcome here. If the animal is going to be killed, that it be killed as painlessly as possible, as quickly as painful.
Well, I understand that. Your contention is it's not a serious bodily injury under the statute.
Well, I would say that if the shooter, as you are saying, if the shooter shot the dog in the leg or the paw and that was all he intended to do, is that what your honor is asking?
No, I've moved on from that, and the hypothetical that I pointed out, now that I've lost track of it, but I was just trying. You seem to say that. Yeah, you seem to suggest that the statutory definitions are exclusive, that killing a dog cruelly cannot be serious bodily injury. It's only the example will be that's cruelty to shoot various parts into the dog ends up dying, and that a charge of that asserts that it constitutes serious bodily injury is not the case, and it's only that it's cruelly injuring the dog. I'm having problems with the exclusive nature of your reading of the statute.
Right, because the felony is to cause serious bodily injury. That's one way to commit the felony. The other two are to torture and to cruelly kill. I think you're describing if you're shooting the dog in the leg, or only, and that's all you're intending to do, that is certainly, it could be cruelty, it could be torture, and it certainly could also be causing a serious physical injury, a lasting physical injury that you could look back upon and say, the dog could have died from that, even though he survived. That even though we only shot him in the leg, he created a substantial risk of death. It's an assessment you make looking backwards.
Does that really make sense? That just because the dog survived, that the perpetrator who had the intention maybe of killing the dog, that it didn't, it should under the interpretation being advanced, that the government then cannot charge a felony only because by happenstance the dog happened to die as opposed to surviving? Does that really make any sense?
If the dog dies from the gunshot, that's the desired result. That's in the text of the law. I think that's the desired result. If the dog is going to be killed, that it die quickly. If an animal is going to be put down quickly and as painlessly as possible, as directly as possible, so it doesn't suffer any prolonged, so it doesn't have prolonged suffering.
So you really think that was the legislature's intent, was to allow someone to go forward and instantaneously kill a dog and therefore be charged as a misdemeanor instead of a felony?
I think that's obvious. That's what the misdemeanor is, killing the animal of another. If it's going to be,
yeah, and which brings up my next question. So and in your brief you suggested that if it was the owner of the dog who killed the dog by shooting it, and so there was instantaneous killing, that he could not be charged for a crime at all. So if someone who's an owner has 6 puppies and just decides, I don't want any more puppies, and decides to shoot all of the 6 puppies, killing them instantaneously, your position is that they can't be charged for a crime at all, even though the legislature, when it updated the statute with the passage of the public law, intended to update what it viewed as antiquated animal cruelty laws. Is that your position, that an owner can never be charged with a crime for instantaneously killing his pets?
Not my position. That's what the text of the statute says. The misdemeanor charge is if you kill the animal of another. That's an element of the charge. Now, there's all kinds of animal cruelty laws all throughout the country. They're rapidly evolving. But the text, and in fact, as my friend for the governor pointed out back in 2010, this would have been a petty misdemeanor, no matter what the facts were. This would have been a petty misdemeanor, 0 to 60 days. The law was upgraded in 2011 to now we have misdemeanors 0 to 1, and we have a felony, which I think the legislature probably only expected to be 0 to 3, not anticipating that the prosecution would tack on the possession and use of a deadly weapon in the commission of a felony charge and ratchet this up to 5 to 28 years for the shooting of a dog. Yes, that's what our law
isn't that
states.
what couldn't they say that that's exactly what the legislature intended when they made it a felony to engage in the 3 degrees that they talked about? Because the whole theory of your case is basically killing an animal by shooting it and having it die instantaneously can never be cruel. I mean, that's basically.
Okay, no, be cruel. Yes.
Yeah, it can never be cruel, because if it was a cruel killing, it would constitute a felony. And
Right.
So the position is that, well, we can kill an animal. And one could even make the position that you could take a samurai sword and chop off the head of a puppy, and because the puppy died instantaneously, that's not cruel, and therefore he can't be prosecuted for a felony for doing so. That's a difficult argument for me to accept.
But I'm just going from the text of the statute, Your Honor. I mean,
Yeah, but we could reconcile the statute by saying that there is no limitation on serious physical injury under the definitions. So a serious physical injury that creates a substantial risk of death, even though death resulted, there was a risk of death by engaging in the action that you did, and the risk ended up becoming 100% realized, but there was still a risk of that. And in your example, where you even indicated that in this case, the shooting impaired the organ, it went through the organ. So you have an impairment of the organ under the substantial risk of physical injury.
That's a strained interpretation of the language, I think, Your Honor. And as Justice Carbolito pointed out, that would render the entire misdemeanor statute nugatory, surplusage, superfluous, something that would never happen.
I don't know if it would render it superfluous, because there might be a situation where the people, based on the circumstances, where even though there is serious physical injury, determines that it's perhaps more appropriate to charge it as a misdemeanor. For example, in a situation where there's a need to put down the animal for a variety of reasons. And so the people may decide that, well, this doesn't warrant a felony charge, but you would still have the misdemeanor charge that would be applicable.
I think that's already contemplated in the law, but we're talking about the wrongful killing of animals here. And all I'm saying is that the text of the statute.
Yeah. So answer my question. So, I mean, I guess you did answer your question. The answer to my question is an owner can, without penalty or without fear, instantaneously kill any animals that it has and never be charged.
Under the elements of the statute, Your Honor, it has to be an animal belonging to another. If it's as long as he's not cruelly killing the puppies or torturing them or doing something to cause them serious lasting injury, then yes, that's what the law contemplates. It's not unusual. That doesn't vary widely from other laws in other states throughout the country, at least laws that have existed in over the last century.
I have one more question. You pointed out that, and the court below actually held there are two frameworks for punishing animal abuse. One for cases where the animal dies, and another where the animal survives. And the argument is that you intended to differentiate the cases where the animal was killed, and that's a misdemeanor, but a case where the animal survives would be a felony offense. And the Chief Justice pointed out that there seems to be an irony with the fact that, and it seems kind of bizarre, that the result of the result that is more serious, death, results in a misdemeanor charge, while the less serious physical injury results in a felony charge.
Because we kill animals.
Is that truly what the legislature intended?
We kill animals all the time for food, for many reasons, and it's widely understood that if you're going to kill an animal, it's best to do it quickly and as painlessly as possible, and that's reflected in this statute here.
That's a little different, Mr. Bishop. I mean, killing for food specifically is exempted under the statute, and it's not subject to a criminal violation.
Right, but I mean, this is we're talking about animals. Animals are different. The law is different with animals than it is with people. A dog runs into the road. Do you slam your brakes like you do if a child runs into the road? Even if there's somebody behind you that's going to crash into you if you slam the brakes too hard. There's a different reaction. There's a different calculus that goes through your mind when you see a dog run into the road and you see a child run into the road. With animals, for centuries, I think the consensus has been that it's better for the animal just to be, if we're going to kill it for whatever reason, for food or for other reasons, that it be killed quickly as possible, quickly and as painlessly as possible. And that's still a misdemeanor. It's still a crime. It's been upgraded from a petty misdemeanor to a misdemeanor in the present statute. It's still a crime. You can go to a year in jail. And if you actually if you torture your own animal, if the owner tortures his own animal, that's still a felony. That's torture. That the torture and the cruelly killing portion of the statute does not require the animal to be your own. So I mean, so even if it is your own, if you torture it, you're liable under the felony for the felony. And the legislature doesn't even mention anything about firearms in the statute. And you would think that when they're envisioning in the misdemeanor statute, the most commonplace example of killing an animal and doing it not cruelly, that is to shoot it. That's just in culture, popular culture, in movies and books. That's what you see. That's how an animal is put down not cruelly. And the legislature, for some reason, didn't really define that. Although there's case law out there which says that shooting an animal is presumptively not cruel unless you're trying to only injure it and cause it to suffer, impairment of limbs or organs, or protracted disfigurement, or to cause only a substantial risk of death. The sense of that phrase, a substantial risk of death, is just not something that you say, that you use, that comes to mind when you talk about an instance like this where the animal has been killed. We don't say.
The case law, though, that you've cited, because you say case law suggests this, I mean, in those particular cases, at least the one that I've read, it's more of a statutory interpretation. It's not by judicial common law, where it says that by shooting an animal, you're not cruelly killing the animal.
Actually, I'm not sure. I think that the Pennsylvania case we cited, there was no mention of firearms in the statute. But certainly it's just the first thing that comes to mind, I think, when you talk about killing an animal not cruelly. do it as quickly and painlessly as possible with a firearm. Firearms have a recognized place in our law, and what they're mostly used for is to kill instantly, as quickly and as get low with as quickly as possible. That's what firearms are for. In this case, the firearm was used for exactly its intended purpose. It wasn't somebody trying to.
My problem with that absolute argument that anytime you shoot an animal, you're not cruelly intending to kill the animal. I just, if an animal is constantly barking at you, an animal is, constantly threatening your family, coming onto your property. I think your frame of mind is not that I'm not going to cruelly kill this animal. It's just by shooting the animal, I'm just going to kill the animal. I think that across the board, saying anytime you use a weapon on an animal that results in death, that's not, there's no intention to cruelly kill the animal.
Across the board, unless there's an indication that you would use the weapon, the gun, intending to cause cruelty, to cause a lingering death, to cause protracted disfigurement or impairment of organs. And there's no indication in this case that the shooter intended other than to kill the animal as quickly as possible. The animal died by all accounts within seconds or a minute, and there's no indication that the shooter intended anything other than that. And so it's just a paradigmatic case of killing. It's a crime. It's still a crime. Killing the animal of another, unless there's some justification for it. But it's not the felony. It's not the felony of cruelly killing the animal, or torturing it. If you hit it with, beat it with a machete or a stick or any other kind of object that's not the quintessential killing implement, a firearm.
Mr. Bishop, the facts that seem to have been presented in support of the indictment don't have any facts related to the cat's death. Is there a difference between the two charges under the law?
Yeah, well, on the cats, as far as the cat, there's no autopsy report on that, of course. There's no, I'm not sure whether there's even I'm not sure if they can even meet the element that this cat belonged to somebody, which is an element of the misdemeanor charge. So if the cat did not belong to anyone and it was shot and killed instantly, that is not, under the text of our statute, that is not a crime at all. If, however, the cat was cruelly killed, if it was shot in such a way to make it have lingering pain, then it could be that could be to cruelly kill the cat, or to cause torture. And in that case, the killing of the cat would be chargeable as a felony.
But aren't those facts that should be left to the trial? Or
well, what we're saying is that even the facts alleged in the indictment don't constitute, even if they prove the facts alleged in the indictment, that does not constitute a felony. All that they constitute is a misdemeanor. All they've charged in the indictment was that the animal of another was killed by shooting, which is the most clear example of the misdemeanor, killing the animal of another. Unless there's some additional facts alleged and proven that the shooting was done in such a manner as to be cruel, torturous, or intending or recklessly causing extended serious bodily injury, that the animal would suffer for an extended period of time and not die directly from the action of the shooter, then that's the difference. They'd have to allege facts that the shooter did not intend to put the animal down directly with the shot.
thank you.
Let me just ask one final question from me. Mr. Bischoff, do you think there's any ambiguity in the statute?
I think that the prosecution, the Attorney General's office, is creating ambiguity, wanting you to go look through the legislative intent. The text of the statute, I think, is pretty clear. There's a difference between the misdemeanor killing of an animal of another, just killing it and getting it done with, and the felony, which doesn't even require it to be the animal of another, it can be any animal or any domestic animal. If it's done cruelly or torturously or with the intended result or even reckless result of causing a lasting serious bodily injury that could have resulted in, that when you look back upon it, you say it could have resulted in a death. You don't look on this situation, you don't look back upon it and say that the injury to the dog could have resulted in its death. That's not how our language works. You say the
Thank you,
animal.
Mr. Bishop. Your time is up, and at this time I'll recognize Ms. Mignola. You've reserved your remaining time, and you are recognized.
Ms. Mendiola, should we distinguish between the two charges based on the support for the killing of the cat? It doesn't seem that there's any indication of how the cat died other than the cat was shot.
Your Honor, the distinguishment between the two charges is not necessarily relevant here, because for the indictment, it alleges the same action for both instances for Pugwa and the neighbor's cat. Both that the defendant caused serious physical injury or tortured the animal by shooting. It's the same allegation for both. What is legally relevant, though, is that the circumstances for that shooting and whether the facts can support that the crime was committed whether the facts of the case support whether the crime was committed is an entirely fact-specific determination for the trial court, a point that you raised. And throughout Mr. Bischoff's arguments, he addresses multiple different facts that he argues are present or not present. But we don't know all of that because we haven't been allowed to proceed through trial to figure out what facts exist or don't yet. But what we do know is the facts. What we do know is the facts we have before us, that Mr. Cruz shot both these animals, would support a charge for causing serious physical injury or torture of the animals. And that's the only procedural requirement threshold that the people is required to meet in order to move forward past the stage of indictment. The defense is entirely correct about one thing. The statute is clear. The language of the statute is clear. We need not look past it, and the court shouldn't look past it because it's clear. And it clearly does not require survival as an element of causing serious physical injury as a felony crime. The defense mentions that this is the paradigmatic case of killing of an animal of another. It certainly is. But if I can read for a moment from Dr. Poole, the territorial vet's description of what happened to Pugwa, he reports that it is likely that Pugwa remained conscious for some minutes after the shooting. Pugwa could not have survived the wounds without immediate surgery, and likely not even had such procedures been possible. There was simply too much damage to the heart, lungs, and adjacent thorax and thoracic limb musculature. Had Pugwa somehow survived, it is unlikely that the front legs would have worked properly. This is a paradigmatic case of causing serious physical injury to an animal. It is of no legal import that Pugwa suffered the worst of outcomes and ultimately bled to his death. But what is legally relevant for the court here is to find that the charge is supported and the people should be allowed to proceed to hold Mr. Cruz accountable. Your Honors, just yesterday morning, a video circulated around social media of shooters in Harmon playing target practice with a sniper-looking rifle and a scope and shooting a dog. The dog yelps out in pain and ran. If the trial court's decision is not reversed, how those shooters are treated more severely as felons, which they should be, or less severely as a misdemeanor, is going to depend entirely on whether the animal lives or dies. And that's just not what the law requires, and it's not what the legislature intended. There are circumstances where a killing of an animal is less severe than causing serious physical injury to an animal. whether those circumstances exist, whether it is or is not more severe, those are fact-specific determinations. Those are fact-specific determinations for the jury. Those are fact-specific determinations that can only be fleshed out and can only be confirmed through the trial process. And let's look at this case specifically. The defense argues that the facts in using a firearm, the facts of this case show that in using the firearm, the defendant took a kill shot and obviously intended to kill Pugwa. There are no facts that it was that the defendant intended to kill Pugwa. There is only the fact that the defendant intended to harm Pugwa. We have to go to trial and figure out, did he intend to kill Pugwa? Because usually if you intend to kill an animal and you intend to do so quickly and humanely, you shoot it straight through the middle of you shoot it toward the middle of the head, a little bit off to the side, so that you instantly, in a millisecond, render that animal insensible and incapable of feeling any pain. You do not shoot it through the chest and through the shoulder to allow the animal to bleed to death for minutes or for however long Pugwa may have laid there and suffered. But what really happened that day is going to be a fact-specific determination for the jury to decide. And what is before this court is that the indictment that was issued as a result of the government going through the grand jury proceeding, the grand jury decided there was enough here. The indictment was dismissed based on the defense's proposition and the trial court's argument that there was an element of the law that wasn't written in the law, but that the element of the law required survival. And the defense points to the need to look to the companion language, and we can do so. In creating section 70.10 and 70.10.1, there's an element that we didn't address, which the legislature created in failure to provide minimum care. That specific language addresses when the failure to do something, when the conduct or the omission of the defendant leads to death, then that behavior should be treated differently. Leads to a particular outcome, that behavior should be treated differently. As a misdemeanor, it's when that failure to provide minimum care leads to physical injury. As a felony, it's when that the failure to provide minimum care leads to serious physical injury. If the legislature intended to separate serious physical injury based on the outcome of survival of the animal, it could have done so in the statutory framework, and it did not. The crux of the defendant's argument and the principal error of the trial court below is that the government should be forced to charge this crime as a misdemeanor and refuses to do so. But that is not for the defense or the court to decide. It is for the government to decide. We've decided to bring it as a felony. That is supported, and we ask this court to reinstate the indictment and allow us to proceed. Thank you, Your Honors.
Thank you, Ms. Mendiola, and your time is up. So councils, normally at this time, we would adjourn and take the case under advisement. But as Justice Torres and our staff attorney, Ms. Erica Eschbach, has provided for a outreach, and we have student attendees. As Justice Torres earlier announced, at this time, we will allow for any questions from the students to the lawyers or the panel, with the limitations that were earlier announced. And Justice Torres?
Yeah, I can manage the questions that are being asked, and there are a number of them. And again, before we get into answering the questions, if any students have a question that they'd like to ask the justices or the lawyers, please use the question and answer mode in the Zoom icon. And if we're able to, we'll, and if you want to be admitted into the virtual courtroom, put the word invite after your question, and we'll try to see if we can make you join us. Maybe this first question I'll direct to Justice Merriman, since Justice Merriman has both served as legislative counsel and also on the court. And it asks, how often do lawmakers consult with judges or justices when they're creating the laws?
Under our codes of judicial conduct, normally justices and judges are not permitted to give opinions about what the law should be. The only exception is when it has to do with the administration of justice. So if there's a bill proposed that would perhaps increase the number of judges, then judges can testify about that. But generally speaking, in a case where, in a bill where they're proposing a change to increase a penalty, create a new crime, something like that, judges and justices try to restrain from discussing those. And the reason is we don't want to form a preconceived notion of how the law should be interpreted. We want to wait until parties come before us with questions or issues about the law and how the facts should be applied in a particular case.
All right, thank you, Justice Merriman. Chief Justice, I'll ask you this next one from another student. And the question is, this case seems to turn heavily on how the statute is interpreted. What should the court look at when looking at legislative intent in a generally speaking?
Yeah, I think some of the tools will be in play here, and so I want to be careful in reference to answering that question. But in generally speaking, normal circumstances, as both counsels point out, you first look at the text of the statute, and if the text is unambiguous, then it ends right there, and you interpret the statute based on the language and the text of the statute. Absent that, and if there is some ambiguity, then legislative intent plays a part and is one of the tools to assist the court in trying to determine what was the intention of the lawmakers when they drafted the language. And as has been stated in parts of the argument, the text, you look at the entire statute and not just a specific word, specific line, but the accompanying sections that may bring it, put it in context and give it, explain it in a better light. And so you then look at the accompanying text. Then you can also look at the legislative record in terms of the public hearings and the statements that were stated at the time the legislature considered the specific statute in question before it passed it. There are other tools, but I'll just end there because of our time limitation.
All right, and let me ask. This one will be directed to both of the attorneys, and their answers may differ. But the question is: should you assess cruelty by the effect of the action or the intent of the actor? And we'll start with Ms. Mendiola first, and then Mr. Bishop. So the question is, how do you assess cruelty? By the action that results, by the effect of the action, or based on the intent of the actor? Ms. Mendiola?
Thank you, Your Honor. The answer for that, I would say, is both. The effect of the action or the intent of the actor is going to be the facts. I've been arguing today all about the fact-specific determinations. But if I could tie this to the question that Chief Justice Carbolito was asked and the answer he was given, related to what constitutes cruelty is the legislative intent. And what we had been arguing about today is the law that started out as Bill 9. And if I could just quickly show an example of what a bill in the legislature looks like, it's I don't know if my camera will capture it, but it'll show the section 1 of the bill. If it doesn't jump straight into amending the language, it'll actually write out legislative findings and intent. So in Bill 9, the legislature addressed examples of cruelty as death from starvation, thirst, or the animals were injured or killed through deliberate acts of cruelty. So it addressed the answer to the question is both, because the effect would be the starvation or thirst or the death of the animal, and then the intent of the actor is whether or not that action was taken deliberately or negligently or what have you.
Mr. Bischoff?
To answer the student's question, I think that the statute is focused primarily upon the animal, not the actor. And as far as the cruelty, I think the focus of the statute is to prevent cruelty being perpetrated, inflicted upon the animal, not so much what was in the mind of the person who injured the animal. I think it's, as far as what's in the mind of the person who injured the animal, we have the standard culpability statute of whether things are done with a conscious purpose, that's intent, whether things are done with an awareness of that it's a practical certainty of the result. That's what's called knowingly. Whether the action is taken with an awareness of a substantial risk of a certain outcome, that is recklessly. In fact, those are the three statutory mens rea culpability elements that are in play here. There's another statutory culpability, mens rea, which is negligent, which is that you should have been aware of a substantial risk to a certain result. This statute we're talking about here does not include a negligent causing of, I guess, serious bodily injury. That would not be a crime. Our statute that we're talking about here today, it lists only intentionally, knowingly, or recklessly causing a certain result. And as far as legislative intent goes, that should be the last resort going to the legislative history. The legislative intent should be, ideally, is expressed in the statute itself. That's, if you're looking for legislative intent, there are 15 people in the legislature. They may have all had they probably all did have different intentions, different takes, different certain small disagreements with one another about what the ultimate language should be, but they ultimately agreed upon a certain text. And it's not so much even the intent of the legislature as the fair meaning of the text. That is what we know for sure, that the legislature agreed upon, is the wording of a text. And that's the
right.
First thing.
Thank you, Mr. Bischoff. There's another question as whether or not the statute applies to all animals or just cats and dogs. And the statute does apply to all animals and is not limited. It's entirely.
Well, Justice Torres froze.
Justices?
Okay, you
okay,
froze.
There's another statute. Okay, can you hear me?
Yes, we can now. Yes.
Okay. There was a question of whether the statute applied to all animals or just cats and dogs. And right. The statute does apply to all animals. It's not limited only to cats and dogs. But there's another question that I'll direct to either of the justices, or maybe both of them can answer. And I can chime in as well, is how much does the oral argument influence your decision in a case?
I don't want to in any way dissuade councils that they did such a great job that it made a decision, it made a determination on my decision coming in. But in all actuality, for the most part, to me personally, the briefs play a large part in reference to persuading me in reference to the case. There's been a substantial amount of hours put in reference to the research and the writing, and which the students did not get to see, that tries to persuade and make the case of each side. And in large part, that determines the outcome in terms of how I see the case. There are instances, and to my surprise, when oral arguments have changed my mind from my position coming into oral arguments. Not often, but there have been instances. But for the most part, the submission on the briefs, the writing, the research plays a very important part. Oral arguments gives us the opportunity to kind of test some of the arguments and the principles and clarify in reference to what was stated in the briefs. But the short answer is there may be instances, but for the most part, I feel that the written briefs are extremely important in persuading me as to the position in a case.
Justice Merriman, would you like to elaborate?
I would generally agree with the Chief Justice, except that I find oral argument extremely important in clarifying concerns or issues, and that could be where I don't think the attorneys were really clear in their written preparations, and I'd like further clarification. Or if the attorneys have both made extremely good arguments, and I would like to sort of fine tune better the differences in the arguments. So I find it an important part of the process.
Okay. Thank you, Justice Merriman. For myself, as the Chief Justice said, we're very well prepared when we come to oral argument. We've researched independently by the justices as well as the research attorneys of the court to help us prepare. But there have been instances in oral argument where counsel has been persuasive and has managed to.
Yeah, Justice Torres continues to come in and out, and so I don't know, Erica, if you can turn on. How much time we have, how much more,
yeah, we just
okay.
have a few more minutes. So one last question, and this will be the end of it if we can, Chief Justice, and I'll direct this question to the people, the prosecution. There's a question from a student on whether the legislature is changed the law because of the incidents in this case. And I'll just leave that to the prosecution, and maybe after she answers that, we can end this session.
All right. Thank you.
Thank you, Your Honor. The answer to that question, as the universe would have it, is hopefully yes. As the universe would have it, the legislature today, as we are discussing Pugua's case, is discussing Pugua's law, which is Bill 185-35. So if students are interested in the legislative discussion about how the laws made this particular law, this law in particular, then they can switch YouTube channels from the judiciary to the legislative YouTube channel and listen to the debate about that. But this law, the law we argued about today came as a result of a pet named Mason. It was one horrible instance among many. Fast forward to today, we have yet again Pugua's case, which is hopefully standing for a change in our public policy and how we treat our animals. So the legislature has not yet changed the law, but is in discussion to do so as we speak.
And before I conclude, in all fairness, Mr. Bishop, you have anything to add to public policy type question?
Well, public policy is made by the legislature. The legislature is assumed to be a reflection of the voters, and the laws are always evolving to reflect different attitudes, the new findings of science, different kinds of outlooks, and there's a bill in front of the legislature right now that is going to, if it passes, it's going to make big changes to the current law, just like the law in 2011 made big changes to the law as it existed in 2010. So, yeah.
Thank you, Mr. Bishop. Well, as Justice Torres indicated, we will bring this hearing now to a close. The case is submitted now to the panel. We will take it under advisement, and we will issue an opinion, just as a written opinion, just as soon as we can. And so I would like again to thank councils for their cooperation in participating in this outreach with students along the late outreach that, as Justice Torres mentioned, we normally do, or I indicated during Law Week. And hopefully we'll get another opportunity when we celebrate Law Week in 2021. And it may hopefully also be in person. And so with that, the court is adjourned. And I thank you all for your assistance and participation. And this matter now will come to a close. Thank you all, and goodbye.
Thank you
Your
very
Honor.
much. Bye.
Bye.
Thank you.